Okay, we're going to start right away. Thank you all very much for coming to this webinar tagged Patent Licensing and Frand. And it is a great honor to be asked to moderate today's webinar. And I'm very pleased to introduce the two of our speakers. First, we have Professor Mark Engelman. Am I correct with the pronunciation, sir?
Engelman, but that's not bad.
Engelman, okay, Engelman, okay. Who is an associate professor at the University of Notre Dame. Mark has acted in numerous high-profile cases for internationally recognized brands, including Glaxo, AstraZeneca, Specsavers, and Apple, drawing on decades of experience as an independent practitioner and an in-house counsel to Dunlop Slazenger and head of IP for the Body Shop International PLC. He was appointed member of the Development Council of the Globe Theatre, was the head of IP at Hardwick, a leading UK set, holding both a degree in pharmacology and a seat on the board of directors for a pharmaceutical company within a group of 14. Mark has a unique advantage advising pharmaceutical and biotech companies. He has a deep commercial understanding of running pharma companies, along with his intrinsic technical knowledge and passion for the subject, provides his clients an unrivaled service, and his core services to clients include IP contracts, pharmaceutical compounds to clinical trials, collaboration agreements, shareholder agreements, patents, litigation, and advocacy. Mark can take direct instruction from companies without any solicitor intermediary, providing an end-to-end service with associated cost savings. Our second speaker is Mr. Olatunde Ojeladun, who is a trademark and patent attorney who works with Inventor International. Olatunde is an ambitious lawyer bringing extensive in-house counsel and law firm expertise in wide variety of disciplines with cognate experience in intellectual property registration, protection, and advisory, corporate and commercial practice. He has handled both contentious and non-contentious matters relating to trademark, patent, and design, drafting and reviewing of commercial documentations, setting up of legal entities, regulatory compliance. He has portrayed excellent leadership qualities and has held several leadership positions at different stages of his career. He's result-oriented and he is always eager to learn and is willing to take on any challenging opportunity. Now, before I go on to ask our speakers to do their presentations, I'll speak a little bit about myself and the company I work for, ESQ Trainings Limited. My name is Akitunde Idowu, a research and development associate, and I work for ESQ Trainings Limited. We focus primarily on providing knowledge sharing sessions such as this webinar, and we also coordinate field or public trainings for companies, law firms, techpreneurs, and in-house trainings for any of our clients that needs our services. Our mission is to expand the frontiers of continuous professional learning with trainings and courses across various areas of practice. We have tagged this webinar series the Launch Our Webinar series because they are slated to hold at 1 p.m. during the lunch break. They will hold 2 times every week, Tuesdays and Thursdays respectively. And after every session, we'll provide the resources in easily accessible formats on the go for everyone who is interested. Please ensure to use the Q&A window to ask your questions, and our panel will attend to them at the end of their presentations. Without further ado, I'll call on Professor Mark to deliver his presentation. Thank you very much, Professor Mark.
Thank you. Can I just clarify, you can see it, everyone can see it? Or do I need to do something else?
Oh, clearly we can see the screen, sir. Thank you very much.
Thank you very much. Right, ladies and gentlemen, thank you for allowing me to come, and I'm very honoured to speak to you alongside Mr. El-Jaradran with regard to his view on, I suspect, what is much the same topic from a different perspective. And because it's quite a complex topic, I think 2 eyes on this subject, or 4 eyes, I should say, on this subject is better than 2. when trying to explain it. So given the limited period, I'm going to rush a little bit through my slides. You can see I'm going to deal with 6 topics: the history of patent license abuse, particularly with reference to historic Supreme Court cases. I need to give you a background into that. And then at the European Union level, what the no-nos of competition law are with respect to patent licensing. And then deal with Frand, specifically the case law in EU concerning Frand and the UK case law, particularly with regard to our recent Supreme Court case, and then identify for you the terms of the acceptable license, which was identified at the end of a judgment by a Mr. Justice Colin Burse in the case which we both, I feel, is going to refer to, and my fellow speaker. So without further ado, I will deal with the first topic, if my computer will let me. Oh, here we are. Can you hear me, everyone? Good.
Yes, sir, we can.
Thank you. So the history of patent right abuse, patent license abuse, has been concerned historically with a number of Supreme Court cases. And Adams and Burke, the Supreme Court, made the first indication of what is known as exhaustion of rights. Exhaustion of rights in very, very simple terms: if I buy a BMW car and it's got a BMW badge on it, when I sell it secondhand, BMW can't exercise trademark rights to prevent the sale of the car, the first sale by BMW within a country, of the second sale by me to whoever wants to buy it from me on a second-hand basis. That principle is exhaustion of rights. And with regard to patents, Adam and Burke was the first case that said once a patented article is sold, the rights are exhausted. Henry and Dick in the US Supreme Court decided that when licensing a patent, a patentee can determine as he wishes that a product license on any terms he so desires. But later, the Supreme Court rode back on that and said because patents are a monopoly right, it condemned the licensing materials which form no part of the patented invention. So you can only patent that and license that within the claims of your patent, and you can't patent a license or grant a license with respect to elements which are not within the claims of your patent. And finally, in Bruloit and Theisco, a patentee cannot collect royalty beyond the terms of his patent, because that too was held to be anti-competitive activity and outside the scope of the patent itself. Patent lasts generally for 20 years, and you can't continue to collect, obviously, a patent license beyond its term. That gives you a rough background of what anti-competitive activity is like and how it is contained by case law. Within Europe, we have the same principle. Article 102 of the Treaty on the Functioning of the European Union provides any abuse by one or more undertakings of a dominant position within the internal market or in a substantial part of it shall be prohibited as incompatible with the internal market so far as it affects trade between member states. That means big companies that hold better than 20 to 30% market share in any particular product, item, intellectual property, etc., are potentially in a dominant position, and they have to behave in a highly appropriate manner if they don't want to infringe competition law. So the block exemption, and we're just going to go through this very briefly as we wind down into the important aspect of Frand, is that it distinguishes between competitors and non-competitors. Competitors are those whose market share must not exceed 20%. Those are at the same level of distribution in the distribution chain as each other. And non-competitors who are upstream or downstream of distribution from each other, their positions must not exceed 30%. But if they don't exceed those percentages, then certain restrictions within their licenses are unacceptable between competitors at the same level of distribution, Restricting a party's abuse to determine price or retail price maintenance is not acceptable. Any reciprocal output production caps is not acceptable. Restrictions licensees to exploit same technology, restriction either party from carrying independent R&D, in other words, stopping your licensee exercising research and development rights, is unacceptable and will be an anti-competitive provision. The allocation of markets or customers between markets subject to a fairly complex set of exceptions. And as between non-competitive, those upstream or downstream, again, retail price maintenance, price fixing is completely unacceptable. Restrictions on passive sales on the part of licensee, a passive sale, which is where somebody contacts you outside the territory you're granted under an exclusive agreement, who you didn't solicit, you're entitled to supply, and any restriction on doing that is unlawful and anti-competitive. Restriction on sales to end users by the licensee of the selection distribution agreement. Selected distribution means the product can be only sold in certain outlets or retailers. They have to be authorized by the commission, notified to the commission. Otherwise, any attempt at that is anti-competitive. And restrictions on passive sales by a licensee in an exclusive territory to another exclusive customer group allocated to another licensee during the first 2 years to protect other licensees is unenforceable. There are others which I won't go into, but you've got them set out in the slides, ladies and gentlemen, if you want them and want to refer to them afterwards. Then we get down to Frand, because this is what the top of our conversation. And the reason I mention the background is not just by way of background, but it sort of tells you also the sort of clauses in an agreement that will be taken as anti-competitive. So ultimately, we're going to end up talking about what a Frand license should look like. But the reason I mention all of these anti-competitive practices and aid memoir to you, that when you are in a situation where you're drafting a Frand license for a client who falls into that rather exclusive set of people who has a standard essential patent, that means a patent that is an application across a vast raft of implementations across a market like mobile phones, you need to be careful of those other clauses I referred to earlier when you get into drafting. So one of the first European court cases in Motorola, Apple offered to take a license to the relevant standard essential patents. Standard essential patents, as I say, are patents that are used across a technology across a number of markets, and without which that technology would not succeed or be able to cross borders. Motorola argued that the offer was not Frand because it was not a worldwide offer to take a license. The EU Commission acknowledged there was no one-size-fits-all solution to identifying Frand. It varies from sector to sector over time. But the European Commission held that Motorola had infringed Article 1.2 of TFEU by seeking and enforcing an injunction against Apple in a German federal court of its SEPs. So that was the third, and that was simply because there was an offer to take a Frand license, and the patentee ignored it. And as we'll see, one mustn't ignore an offer by a patentee to take a license. So when we look at Frand case law, one of the earlier cases that came out concerned a standard essential patent for a mobile phone standard LTE, which comprised a body of 4,700 patents. Huawei Technologies sued ZTE Corporation, and the court held Huawei and ZTE engaged in discussions. The infringement of each patent, negotiation of a patent license. ZTE proposed but did not pay the royalty due to Huawei, and Huawei sought an infringement injunction, which was referred to the Court of Justice, and ZTE sought opposition to the grant of the patent. It was held, Huawei. The question is, does the standard essential patent holder Huawei infringe Article 102 of TFEU by abusing its dominant position? And the answer to the court was the enforcement of IPR within the context of SEP's standard essential patents requires the defendant shown itself to objectively not to be ready, willing, and able to conclude a licensing agreement. Therefore, the obvious is the opposite is true. If it were to hold itself ready, willing, and able to accept a license, then an injunction wouldn't be granted against it. The IPR owner must offer the defendant written terms, including the royalty and the way it's arrived at, and D must act in a diligent manner and a serious manner, and not purely tactically or in a dilatory but serious manner. In other words, it intends to take the license to avoid being injuncted. The next case, Nokia, and Daimler is a draft judgment waiting to be handed down that's just been published by the European Court, or the Court of Justice of the European Union. In this case, Nokia sought IP infringement proceedings and an injunction against Daimler for the use in Daimler cars of a telecommunication system. In other words, effectively a mobile phone, and the cars contained telematic control systems which connect them to the internet for the purpose of music data streaming. So you could listen to all your most popular music inside your Daimler car. Daimler's systems were not manufactured by them, but manufactured by upstream manufacturers who then supplied them the end components. And Nokia offered 2 tiers of license. Tier 1 for suppliers of parts to cars manufactured, in other words, the end product, and Tier 2 with a limited license for R&D. Notice those words, with a limited license for research and development. I want you to cast your mind back to those cases I talked to you about how within TEFL you mustn't restrict R&D. And further, the defense provided further license to provide further license to patent. Nokia argued various issues, that the patent was a component of the finished product, that licensing upstream was permissible because it allowed it to exercise the exhaustion of rights with regard to resale of its products downstream, and that, it said, was commercially fair. Downstream manufacturers do not benefit from the Frand license, it said. They need to come back to us to get a patent license. And not every component is subject to an SEP, and it's not relevant because the finished product contained non-SEP elements, therefore we're not liable. And the defendant was also unwilling to take a license because of this upstream issue. Daimler argued, on the other hand, that a standard essential patent holder must offer a license, and that a supplier must have a license on a priority basis, and rules from other industries as to how this works are not relevant. Every case turns on its own facts, and it's an abuse to the suppliers only given access to the protected technology, and a defendant can't act in an economically independent manner. The court held in a draft preliminary ruling that hasn't been handed down yet, is about to be handed down, that Nokia must grant the license applicant a share of the SP technology, so it enables its free competition, that there must be unrestricted licensing by Nokia, and if it wants to rely on exhaustion, it's entitled to rely on international exhaustion, but within jurisdiction exhaustion, it can't differentiate between upstream and downstream manufacturers. And that is what is set out in paragraph 3. And the limitations of the exhaustion principle can be overcome, as I say, by international exhaustion. And so Nokia was found to be in the wrong. No reasons for efficiency militate against the obligation to grant a license. The manufacturer might therefore accept the license, and the court justice made it clear what the steps are. You must notify of the infringement of the patent by the SEP holder. There must be a request for licensing and submission of a Frand compliant license. That's fair and reasonable and non-discriminatory terms. That's what Frand means, and must be taken before proceedings for a prohibited injunction are brought. And it is possible that once the injunction has been sought, it is possible to remedy it as the case moves on to trial. So that is a judgment yet to come out, but in draft form from the ECJ. I just add, now turn to the next topic, which is UK cases rather than European. And one of the first cases is all about disclosure. You'll see the relevance of this arises as we move on. But in order to determine royalties, one often needs documentation which assesses how royalties arrived at in third-party cases, as well as between the parties to the SEP license agreements. So a previous history of granting licenses by the SEP patent holder are relevant to a determination of the royalty under any new SEP. And here, in a disclosure application between TQ Delta LCC and Xi XL Communications, disclosure of royalty payments were made against the patentee. It had disclosed what it had offered other licensees, but the disclosure request with regard to third parties' patent licenses was refused on the basis that there were little probative value, disproportionate, and subject to third-party legal privilege. So there were limitations about what you can get in terms of licenses. Then we go to the development in the further UK case law, a couple of minor cases, I suppose, compared to what we're going to deal with when we get to Unwired. But InterDigital and Lenovo, the computer manufacturer, this is about a patent 3G minimizing padding in ETFC transport format combination, basically packing more data into a signal. It was an SEP on 3 indicia, but the patent was held invalid, and therefore the Frand license didn't need to be granted with respect to the threat of an injunction. Optis Cellular Technology and Apple Retail, the next case in 2021, I should say the previous case, because the InterDigital case was this year, and last year was the Optis Cellular Technology. 8 patents declared as SEP by ETSI. ETSI, by the way, ladies and gentlemen, is the body which organizes the grant of Frand patents in the telecoms industry and is a French-based entity, which we'll come on to. In that case, D's agreed to take Frand on conditions that the court, only if the court ordered it, that the court would order an injunction, and D would only be injunction even if D entered into a Frand license. The ETSI policy, the court held that the ETSI policy was a contractual obligation between the patentee and the defendant had to take a license and could not make it conditional on any basis, and therefore the injunction was granted. We then come on to the important case, which I know Mr. Ajalandun also covers, which is Unwired Planet International. So, as I say, the standard setting organization, this is almost a collecting society that collects these standard essential patents within industries. And it's not just patents, by the way. These organizations also look at copyright, and they also look at other intellectual property rights. They don't look at trademarks, but they can grant licenses which are or arrange the granting of licenses to patents, to technology which is useful, as I say, across the board. So this ETSI is set up in France, and it has a policy and contractual framework governed by French law. It has 800 members in 66 countries, and the standards for the patents it holds in respect to telecoms covers 2G, 3G, 4G, but not 5G. ETSI requires patent owners to enter into an irrevocable undertaking to contract with it to allow implementers to obtain a Frand license, ladies and gentlemen. So looking at the Unwired case, it was pointed out, and I'm referring to the Supreme Court case, but I'll also get back to the High Court level because it's important. Clause 6 is set out there, basically how the policy works when essential IPR related to a standard or technical specification is brought to the attention of ETSI. The Director General of ETSI shall immediately request the owner to give 3 months an irrevocable undertaking in writing is prepared to grant an irrevocable license on fair and reasonable non-discriminatory Frand terms and conditions under IPR. The facts was in 2013, Unwired acquired a portfolio of patents and patent applications from Ericsson. They didn't actually work the patents themselves. They're almost like, one might say, tentatively a patent troll. They owned everybody else's patents and held on to them. And they covered a large number of patents in a large number of countries. 276 patents in question were considered to be essential patents, of which 29 of that portfolio were United Kingdom patents. And that's relevant to the jurisdiction, as we'll come to the United Kingdom court. On jurisdiction, the Supreme Court held the Huawei, who had used the technology, said, you don't have jurisdiction to hear this case. And the United Kingdom court said, based on the US line of authority, whilst the validity and infringement of national patent were the exclusive jurisdiction of the court of where the patents are granted, we know that under the terms of the Brussels Convention, and also when agreements fall out, so it's where registered intellectual property is registered as the jurisdiction of where a dispute takes place. But these were United Kingdom patents, so on jurisdiction, the United Kingdom was the correct jurisdiction to fight the case. And also the contractual arrangement, ETSI gave the English court jurisdiction to determine the Frand license. And we'll see as we go on, the Frand license is subject under ETSI, under its grant of Frand licenses, to the jurisdiction of the English courts and subject to English law. So the IPR policy permitted an injunction where infringement is established and a irrevocable undertaking to offer a Frand license on terms refused was subject to English contract law. The the second argument on the determination of the High Court of the terms of the license, in other words, the actual negotiated terms between Huawei and the patent holders. It said that negotiation undertaken by the High Court Judge, Mr. Colin Burse, was acceptable. It was contractual in nature. These were UK patents. The court had jurisdiction. The policy said that when patents were invalid or not standard essential patents, which some of the portfolio weren't, they weren't all, and they might not have been all valid, was part of the risk that contractually the parties entered into when entering and undertaking the policy of ETSI. Therefore, they both knew the risk, and whilst it was argued that where would they fight arguments about invalid patents, they said it still meant that it didn't make any difference and wouldn't affect the royalty rate that was the subject of the Frand patent, because both parties accept that those variables might take place when entering into the agreement. Further, the High Court determined the royalties based on the High Court, when determining the royalties, was acceptable, and because there was always a reservation of right to redress royalty pay if a patent was ultimately challenged. Therefore, the royalty rate was not set in stone, but could be varied by subsequent event. The Supreme Court also looked at practices undertaken in the United States, Germany, China, Japan, and the EU, and said that they were doing exactly the same thing, so that was okay too. Then the argument on forum non-conveniens, which Huawei argued there were better jurisdictions to fight this case than the United Kingdom, and it only put forward one other, China. It said China would be a good place to fight this. But what the Supreme Court said, China couldn't deal with the validity of patents, nor determine Frand, which was subject, as I say, to English law, and therefore China was not a better forum conveniens for the dispute in the United Kingdom. The English courts were. Then, was the Frand license non-discriminatory and truly Frand? Huawei said the royalty rate was unfair because there was a certain patent within the portfolio, a Samsung license, and it was at a very low rate, and it said the royalty should be dropped because of the existence of a very low licensing by Samsung. As it turned out, that Samsung license, which should have been granted, actually was only because the company to whom Samsung had sold its portfolio was in financial distress. So the negotiating position of parties was so bad that the royalty rate dropped. And the Supreme Court said that was just because of that instance, doesn't mean the judge got the royalty rate wrong. All of those facts were relevant to how he arrived at the royalty rate. In terms of competition law, there was an argument about, as you know, ladies and gentlemen, the issue of notice and consultation prior to seeking an injunction, and the Supreme Court held that had taken place. And regard the final argument of Huawei was that damages were an adequate remedy in the grant of an injunction, because part of the test for an interim injunction is whether the damages are an adequate remedy. And the court said to accept the argument that damages is an adequate remedy in lieu of an injunction were basically to destroy the very basis of how Frand operates in the agreement. The only way a Frand license is granted is an ongoing threat to grant an interim injunction against the user, which brings me to my almost final slide, penultimate slide. This is what the license looks like, ladies and gentlemen. And if I can invite you, if you look at the citation 2017 EWHC 1304, you will find the case before Mr. Colin Burse on the internet, and at the very end of the judgment is the license in question granted by ETSI. You've got to remember, every SSO grants its different licenses. They don't all follow the same terms. I only point out the key provisions of it for you. License patents are scheduled to the back of the agreement, of which there are many hundreds, as you can imagine. And another important, interesting issue is the average selling price is the lower price upon which royalty could be charged. So there was a clause in the agreement which set a minimum lower royalty rate, which is interesting and I rarely see in licenses. The territory of the license was worldwide. The license was granted a non-exclusive license with a right to grant sub-licenses. Do you remember that upstream and downstream argument before the European Court of Justice? Obviously is correct, because the beneficiary of an ETSI license should be able to grant downstream licenses, and they shouldn't be inhibited by patent infringement injunctions. But the royalty rates, this is subject to the market. We're dealing in telecoms, varied between 0.005 and 0.06, because you're dealing with obviously component parts of mass manufactured technology. and the royalty on infrastructure equipment within the telecoms industry differ very much from those royalty rates. There was auditing of, obviously, of the licensee's sales. The term was 7 years. And of course, as I said before, the law was the law of England and Wales. And so lastly, the conclusion ledger, and I ask you, forgive my dyslexic typing of the word Frand as Frand. I suffer a tiny bit of dyslexia, so forgive me for that. And I didn't spot it. So point one, if you're going to draft or seek to draft on behalf of either an SSC or a licensee, you adopt the Frand license set out in the untitled agreement. That two, avoid any of the competition pitfalls I've identified, that it's not exhaustive, but be mindful of them as they arise within the US cases and the EU block exemption, which are a good indication of where the anti-competitive conduct might be identified. So you want to avoid clauses that fall within those. And then when seeking a royalty rate, you should approach it the way Colin Burst approached it in the High Court, because his approach was endorsed by the Supreme Court, ultimately on appeal through the Court of Appeal to the Supreme Court in the United Kingdom. Ladies and gentlemen, I want to thank you very much. I hope I haven't overrun.
Thank you so much, Professor Mark. That was a very detailed presentation. We're very grateful. At this point, we would move to Mr. Olatunde's presentation. And please note, all attendees, you can use the Q&A window there to type in your questions, and they'll be answered after Mr. Olatunde's presentation. Thank you very much. Over to you, Mr. Olatunde.
Good afternoon, everyone. Mr. Akintunde, can you see my screen?
Yes, clearly, sir. Good afternoon, sir.
Good afternoon. Professor Mark, thanks so much for the lecture. I was thinking we'll almost say the same things as if we discussed before this lecture, that we should take a different path. It's as if you took the part of the case law and you lecture us deeply on the cases. Why I take the other route of definitive and explaining what Frand and patent licensing is. Thank you so much for the lecture, Mr. Mark. Professor Mark, I really appreciate you. Yeah, to start with, since we are taking different paths, I will start from the definition of a patent. I said a patent is the territorial right granted by the state to a right holder to exclude others from commercially exploiting the invention for a limited period in return for the disclosure of invention, so that others may also gain the benefit from it. Sometimes I refer, or it has been referred to as a monopoly right, because it is given to a person to exclude others. In that sense, I will go straight to what we mean by a patent licensing. A patent licensing is an agreement that allows the licensee to commercially make, use, and sell an invention for a specific period. The owner of the invention, the patent, is the licensor, while the receiver of the license is the licensee. Licensing deals involves payment of the license. The licensor will either receive a single time payment or as continued payments, known as royalty, depending upon what is agreed between the licensor and the licensee. Frand. Frand is an acronym for fair, reasonable, and non-discriminatory. Frand terms are implemented to ensure that intellectual property rights owners provide licenses to organizations requiring use of standard essential patents, SEP, on fair, reasonable, and non-discriminatory ground. And I try to give an explanation of what an SEP is. A standard essential patent is a patent claiming technology that is not essential to an industry standards use. With technology developing faster than ever, it is no surprise that the licensing of the SCPs is being requested more frequently, correlating with an increase in Frand litigation. This presentation is based on licenses and Frand in the telecommunication industry, and in particular case, to the case of Huawei. Nature of Frand. The nature of Frand obligations and the legal basis under which it arises has a material impact on how the courts address Frand disputes. Countries have established standard setting organizations. I try to give an explanation of a standard setting organization so that everyone will be on the same page. I say a standard setting organization puts in place framework which require patent owners, which contributes to the standardization process to offer licenses to willing implementers on Frand terms. Often, this obligation will be contractual in nature. For instance, in Europe, it is referred to as ETSI, the European Telecommunications Standard Institute. The ETSI contractually requires its members to abide by its IPR policy, which imposes a Frand litigation. Nature of Frand in the US. At present, the US Court of Appeals for the Ninth Circuit has held that a standard essential patent holders Frand commitment to a standard setting organizations creates a legally binding contract that standard implementers can seek to enforce it as third-party beneficiaries. That was in the case of Microsoft and Motorola. In most cases, resolution of a Frand dispute between an SCP holder and a standard implementer involves the court ordering the parties to enter into a license on terms judged to be fair, reasonable, and non-discriminatory. There's no formal definition of what constitutes Frand terms, but at least one court has stated that a licensee must be offered a license on the same term as similar situated prior licensees. Now, the case I'm using as my focus in this presentation is the case of the Unwired Planet International Limited. I know Professor also adumbrates well on this. This is the part of landmark patent infringement case where Unwired Planet, a patent assertion entity, a company that acquires patent, a patent assertion entity is a company that acquires patent from third parties and seek to generate revenue by asserting them against alleged infringers. Unwired Planet has accrued from Ericsson certain standard essential patents used in smartphones and network equipment, has sued Samsung, Google, and Hawaii for infringing the SCP's Google. This is in the court of first instance in the High Court. The Unwired Planet, let me give a brief overview. Unwired Planet is a patent assertion entity. That is to say, it bought the patent from Ericsson. And what patent assertion entity does is that they don't use the patent. All they do is to go seek after the infringers of a patent by trying to generate revenue. So in this case, Unwired Planet sued Samsung, Google, and Hawaii for the patent of Ericsson that was transferred to Unwired Planet. Samsung and Hawaii have raised various competition law defenses that Ericsson constitutes to derive licensing income from the patent assertion entity on an ongoing basis. Among other things, it is contended that Ericsson is seeking to circumvent its own obligation to license its patents on fair, reasonable, and non-discriminatory terms by using a privateer. Ericsson was later joined to the action. In the High Court, Briggs J of the UK court struck one of Samsung's defenses. The defense relates to the complaint about the effectiveness of the transfer from Ericsson of its obligation to license essential patents on Frand terms. Samsung argued, among other things, that the content of Ericsson's original non-discrimination obligation would be circumvented by Ericsson transferring the patents to the patent assertion entity without the new entity needing to have regard to Ericsson's duty of non-discrimination. The High Court ruled that this contention should be struck out. It was enough for Unwired Planet to make a fresh Frand declaration of its own. At the Court of Appeal, the court overruled the High Court on the defense raised by Samsung. It has accepted that Samsung has an arguable case that the arrangement whereby Ericsson transferred the SCPs to Unwired Planet is in breach of Article 10 TFEU, and void because of the failure to ensure that Unwired Planet will respect the non-discrimination aspect of recent Frand obligation. It upheld the judge on another aspect of the complaint, however, which related to whether the transfer of the patent had given prospective licensees the same enforceable right to insist on Frand terms as such persons used to have against Ericsson, when Ericsson owned and licensed the patent directly. The appeal court accepted Samsung's argument that it has a realistic prospect for persuading the trial judge that it would be anti-competitive for Unwired Planet to be able to charge license fees, which are significantly higher than those which Ericsson itself charged, and which would have been discriminatory having regard to Ericsson's existing licenses. Licenses had Ericsson sought to change them directly. He recognized that these higher license fees could distort or restrict competition in downstream markets to the detriment of the consumers. Samsung later settled with Unwired and was issued a global license. Unwired proceeded to the Supreme Court. At the Supreme Court, the court decided that the terms of the Frand license between the parties was a global license based on the fact of the case. The court held thus: we recognize as undisputed, A, that questions as to the validity and infringement of a national patent are within the exclusive jurisdictions of the court of the state, which has granted the patent, and B, that in the absence of the IPR policy, an English court could not determine a Frand license of a portfolio of patents, which included foreign patents. It is contractual arrangement which ETSI has created in its IPR policy, which gives the court jurisdiction to determine a Frand license. In conclusion, what the court was trying to examine is that saying that the global license issued to Samsung is not in breach of any terms if the same is not issued to Huawei, because it is a global license. And the fact that it can charge a higher fee for the license because it is a global license that is being granted compared to what Ericsson was initially granted. And the court also observed that it will not be convenient to be going to different jurisdictions to enforce the right given to each of the companies. But in America, the striking thing is that the American courts believe that it will be more difficult to enforce a global license because intellectual property, which patent is one of it is territorial in nature. And each territory, each nation will want to protect its own invention. As such, to protect it, it will be difficult to protect a global license as decided by the UK court. Thank you so much.
Thank you very much, Mr. Olatunde. Thank you very much. That was also a very, very insightful session. Again, we want to appreciate our panel for a very detailed and a very, very insightful speaking session. Thank you so much. At this point, we'll take questions and answers. Please, all attendees, if you have questions, please drop them in the Q&A so our panelists can attend to them right now. In the meantime, while we expect questions from our attendees, I have a question for both Professor Mark and Mr. Olatunde. What problems are associated with standard essential patents and their licensing?
Well, it's a good question. The problems are always that in any patent licensing scenario, like buying any asset, a party wants to know what the true price is and whether that price is fair. When you hold a monopoly on something, you can effectively determine the price. And so what Frand does is it creates, as the word suggests, fairness, so that so there is an incentive for the patent owner to join this club, like Etsy, in order to allow its patents to be not only licensed, but licensed across many borders. And it's good for the patentee because there is a court intervention to determine how fair the license is. And in absence of that system, it would be very difficult for the licensee to determine a fair license.
Thank you very much, sir. Does Mr. Olatide want to weigh in on that?
Sorry, please, I didn't get the question clearly.
Oh, okay, so the question was, what are the problems that are associated with standard essential patents and their licensing?
Okay, standard essential patents, because it's used in the particular industry, the process, the problem that are associated with them has to do with the right granted by patents in itself. Like I said earlier when I was starting off, I said patent itself is a monopoly, and it has to balance the monopoly and the usage of the patent. And the essence of registering a patent is also to disclose the patent. So therefore, the problem that associates with the SCPs are strictly that companies may not want to disclose their inventions so that they can monopolistically hold on to their inventions. Thank you.
All right, thank you very much, sir. Thank you very much. That was very good. Another question here is that, can you explain what the concept comparable market principle is? And how does that integrate in terms of license agreement determination? Do you understand that, sir?
Oh, who is that to?
Any of you can answer.
Yeah. Could you just repeat it one more time, please?
Okay. I said, can you explain what the concept of comparable market principle, what does it mean? And how does it integrate with the license agreement determination?
I'm going to have to look that term up, I'm afraid.
Okay.
So I will do that now.
All right, sir.
Right. Well, tell me if I'm wrong, and whoever asked that question, but it appears to be a real estate valuation. Would that be right? I don't know. But the concept, so in other words, an attempt at arriving at a proper price. And if you're dealing with land, I hope I've got this answer right, and there's not some other meaning, but if you're dealing with an assessment of the true price of land, and you're dealing with, so that is what comparable market principle is, a comparable price, and you're looking at a comparable price with regard in completely dissimilar manner to a patent. Although I will say this, the underlying principles of patent law and land law, actually, patent law derives from land law principles, as does a lot of intellectual properties. They're not so far apart as they first appear. They're both born, land law predates and gives intellectual property a lot of its ideas. But coming back to the question, comparable market principle is exactly, I think, what Etsy and other bodies like Etsy are trying to do. They're trying to bring together loads of patents that everybody needs and then determine a fair and comparable market price for those patents using a whole range of data, principally by two methods. One method is looking at how a patent licensee previously licensed those patents, and also looking at how others in the market license those patents, and including other factors such as the invalidity of the patents, the inclusion of non-standard patents in the portfolio in order to arrive at a fair determination of what the price should be. So in principle, they're trying to find both one is the definition of fair market value as it relates to law, and the other one is a mechanism achieving it as it relates to patent law.
All right, thank you very much, sir. Thank you very much. Yeah, that answers the question. So we have two questions in our question and answer window. The first question is that if I discover that someone else is using or has used my invention without my permission, what steps can I take, knowing fully well that I don't have a patent license?
So, is this for me again, or shall I allow my friend, my fellow colleague to take it?
Yeah, I think both of you can weigh in on the question. That's fine.
All right, Professor want me to take that. Okay, the question is that he has an invention, but it's not registered.
Yes.
And another person is using it
without his permission.
All right, like patent, you need to clearly understand that patent is a right granted by authority. Where it is not registered, you do not have the right. Unlike copyright, the moment the work is created, it is inherent from the date of your creation of the work, you are covered by it. But patent is a right that is applied for and will be granted if all the requirements are complied with. So therefore, if the patent is not registered, it has no right to it. And it is first to register. It's first to register that holds the right to it. Thank you.
Thank you very much, sir. So that means the person cannot take any steps, to perhaps maybe protect the invention or what? Or does that mean that the person has to file a patent application now to protect the invention now?
Yes, the question is this: if the patent has not been, the other person has not registered, the best is to quickly go and protect yourself. And after you protect yourself, you can now take up an action. But it still does not mean that you can still not take an action in court. If you can prove that you have been using the patent long before the usage of the other party, so you can stop the other party. I think Professor wants to say something.
Well, if I take for an example, let's say the invention is to a mobile phone, for example, and we had this, Apple brought proceedings in the United Kingdom. So inside a mobile phone, there are a great number of inventions, technological inventions, chips, etc., which are the subject of patent protection. But if Apple failed, which of course it didn't, to obtain patents for its inventions within its mobile phone, it can also proceed on how the article is designed. So patents are one level of protection of a product, but we have many others. Copyright, as Mr. Edgelund explained, is also a potential mechanism of protecting a product. So is design right, where you can register a design. And there is also branding, if it's got a brand on it, or if it contains confidential information, that also is a basis for proceeding against someone. And the steps you take is, once you've identified which intellectual property right has been infringed, then you can instruct a lawyer and take infringement proceedings for the infringement of that type of intellectual property.
All right, so thank you very much. That answers it for me. So another person asked here, says, please, I didn't get the full meaning of TFEU. What's the meaning?
TFEU, I had it on my slide, but I just want to make it short. It is the Treaty on the Functioning of the European Union. The treaty. I
didn't get that, sir.
Treaty. The treaty. I'll write it down. I'll type the answer. Treaty on,
Treaty on the Function of the European Union.
correct. Forgive me, my typing is slow. There we go. Hope that comes up. Did that come up? It should. I sent it. I hope. Yeah, I think it answered. Yeah. Treaty on the Function of the European Union. Yes, good.
Yes, so we can see that. Thank you so much. Thank you very much. At this moment, we don't have any other questions. So I want to believe that every of our attendees really enjoyed this session today. And I want to say a big thank you to each of our speakers who have taken time out of their busy schedule to actually attend to this webinar knowledge sharing session. Thank you so very much, Professor Mark. Thank you, Mr. Ojelado. We are very grateful. And we want to say a very big thank you to all our sponsors, the African Law Practice, ALP, Farmsville Solicitors, GLIS & Co, Advocates Law Practice, DOA, for making this webinar possible today. We also want to thank all the attendees for joining in on today's webinar. Please note that the next webinar series holds on Tuesday, and we definitely love to have you on board. Thank you very much, everyone. Do enjoy the rest of it.
Thank you.
Thank you so much, Professor Mark.
Bye.
That was very.
Thank you.
Thank you, Professor.
Sunday.
Thank you.
Yeah. Have a great day, Sals.
Thank you. You too. Bye.
Yeah, bye-bye. Thank you.